Okay, apologies for the heat in here. It's not typical, but this transitional season tends to be a little bit of a challenge for our air conditioning system, I gather. So my name is Jessie Hill. I'm the Associate Dean for Academic Affairs and the Judge Ben C. Green Professor of Law here at Case. And it is my honor and my pleasure to introduce tonight's Schroeder Scholar in Residence, Nancy Northup. The Schroeder Lecture is named for Oliver C. Schroeder, Jr., who joined the faculty of what was then Western Reserve Law School in 1948. And in 1953, he founded the Law Medicine Center, which was the first law school program in health law in the country. By the terms of the charter of the lectureship, the Schroeder Scholar in Residence is to be selected on the basis of scholarly distinction and contribution in the arenas of health policy and law. This description undoubtedly fits tonight's speaker. Nancy Northup is president and CEO of the Center for Reproductive Rights, one of the leading impact litigation groups working on women's rights and access to reproductive health care. The Center, a global human rights organization that uses constitutional and international law to secure women's reproductive freedom, has brought groundbreaking cases before national courts, UN committees, and regional human rights bodies, and it has built the legal capacity of women's rights advocates in over 45 countries. Ms. Northup joined the Center in 2003 after working as a constitutional litigator, federal prosecutor, and women's rights advocate. During that time, she has worked to establish that a woman's right to control her reproductive life is secured as a fundamental human right. Before coming to the Center, Ms. Northup was the founding director of the Democracy Program at the Brennan Center for Justice at NYU School of Law. And before that, she served as a prosecutor and deputy chief of appeals in the U.S. Attorney's Office for the Southern District of New York. Under Nancy's leadership, the center has almost tripled in size and added 4 regional offices in Geneva, Bogota, Nairobi, and Kathmandu. You'll be hearing shortly, I'm sure, about some of the amazing work that the center has done and is doing in the area of reproductive rights. But before that, I just wanted to tell you a few more things about Nancy that I've learned in poking around that you might not be hearing about from her. I've learned that Nancy was an Army brat who lived in a variety of places growing up. When you meet her and hear from her and hear about all the things the center has done, you might not be surprised that she's had this kind of worldly upbringing, but you might be surprised to learn that she is also apparently a big Elvis fan. Her reputation as the leader of the Center for Reproductive Rights is that she's a hard-working boss who has very high expectations of her employees. And these high expectations apparently even extend to having fun. She has a fun committee that is charged with pulling off an annual raucous karaoke night and a must-attend holiday party. Dancing is required. And apparently there was even a party for the royal wedding a few years back, and I'm told that small hats were worn by all. Returning to a serious note, though, the center has made enormous strides under Nancy's leadership and has been a hugely important advocacy organization for women's rights at home and abroad. Through Nancy's leadership and the work of its phenomenal attorneys, the center has become known for its innovative, cutting-edge litigation strategies, for its global focus, and for the wide reach of its work into the realms of law and policy, as well as legal education and public opinion. Please join me in welcoming Nancy Northup to the podium.
Well, thank you, Professor Hill, and also thanks to Dean Berg and Professor Melman for having me here today and for hosting this lecture. The thing about Elvis was that when I go somewhere, I like to take in what's going on. So in that case, we were going to visit our clinic in Jackson, Mississippi that we represent, actually in a case that's now pending cert before the Supreme Court. And I insisted that rather than go to Jackson directly, that we fly into Memphis so I could see Graceland before we went and drove to Jackson. And last night, I was so pleased to come into town and realize there were a million marvelous things walking distance from the law school. So I was able to take in both the botanical gardens and the art museum, and I am a complete Cleveland convert right now. So I am jealous of all of you who get to work and live and study here in Cleveland and have so much at your disposal. And I'm also really pleased to be here and be able to share with you my perspectives as the leader of an organization that has for over 20 years, since the time of the case of Planned Parenthood versus Casey, which we'll be talking about today and was argued by one of our founders, Kitty Colbert, been on the front lines of protecting women's access to reproductive health care in the US and around the world. And at the center, as Professor Hill said, we work to establish that reproductive rights are protected as fundamental rights by governments. And we work on a range of issues, from access to essential obstetrics care as a fundamental human rights issue, access to contraception, and against violations such as child marriage and FGM. And on a range of these issues brings us today to my talking to you about what is a crisis, I think, here in the United States on the access to abortion services. Before I start, though, I want to get a sense, because we'll be doing Q&A later, of the room, of who's here. So if I could see, if you are a law student, can you raise your hand? Lots of law students in the house. And professors of law? And any doctors? Ooh, no doctors in the house. Well, we'll be able to say what we want about medicine and fact-based medicine. And we also have folks from the community who are here tonight. Well, welcome to all of you, and I look forward to our discussion. In giving the Schroeder lecture, I looked to see who some of my predecessors were in this podium. And it's been 9 years since the topic of reproductive rights has been addressed by one of the Schroeder lecturers. And that was 9 years ago, when Susan Wood was here to talk to you about the battle for getting emergency contraception over the counter in the United States. And Professor Wood was the former Assistant Commissioner for Women's Health at the Food and Drug Association, who resigned in protest over the lack of evidence-based medicine used to make the decision initially about over-the-counter availability of emergency contraception. And the Center for Reproductive Rights sued the FDA in that case and in remarks that Professor Schroeder made. Here we are 9 years later, and we're still going to be talking about what was the topic of Professor Schroeder's remarks, which is how do we get science and evidence-based medicine to be the primary drivers of policy and law when it comes to women's reproductive health. And I particularly enjoyed preparing for today's lecture because I knew that I would be in the halls here at the Center for Law and Medicine where facts matter, where evidence-based medicine matters, where the rule of law is respected, and where reasoned argument is the mode of discourse. This is not the world in which I live. I live in a world in which the issue of women's reproductive health care has become so politicized that facts and medicine and reasoned argument often do not carry the debate at all. And the next case that will be before the Supreme Court is going to be about whether fact-based medicine is going to be the evaluative standard of laws and regulations that have an impact on abortion, or whether or not what is put forward by politicians seeking to block access to abortion gets basically a rubber stamp by the courts. Will there be realistic review or a rubber stamp? And we'll be talking about that. So first I want to kind of ground us before we begin, because this issue of women's reproductive health is so politicized. I want to ground us a little bit in biology and some public health facts. Then I'm going to lay out the latest tactics of those who would seek to ban abortion, namely the pretextual state laws that are passed under the guise of health and safety, but are in fact designed to shut down clinics and ban access to abortion services that have been sweeping the states of the nation in the last 5 years. I'll then focus on the state of Texas, both because it is one of the most radical examples of those laws, but also because it is the case most likely to be taken by the Supreme Court this term, and take a look at some of the legal arguments we'll be making in that case. And finally, I'm going to end with talking a little bit about what I think is very necessary in the area of law and policy and reproductive health, and specifically access to abortion services, which would be a federal statutory claim that could address some of these laws and make sure that evidence and facts and science are the test of these regulations. But I want to pause at the outset to say a few things, as I said, about a 10,000-foot view on women's reproductive health and some basic facts about contraception and pregnancy. It's good to remember that without access to contraception, a sexually active heterosexual woman would likely have 9 or 10 pregnancies in her lifetime. And without access to emergency obstetrics care, many women die. That is true today in the world. It was true in our history here in this country. And to give you a stark sense of the difference that healthcare makes in a woman's life, in Chad today, your lifetime risk of dying in connection with pregnancy is 1 in 15. In Norway, it's 1 in 15,000. There is nothing different biologically from women in Chad and women in Norway. The difference between 1 in 15 and 1 in 15,000 is access to emergency obstetrics care, and also access to contraception, because that leads to less pregnancies, and each pregnancy causes a risk of serious health issues and even death. And one of the things that is true and fascinating and interesting about the area of pregnancy and the law is that pregnancy, as the Supreme Court has said, is sui generis to the human experience, and thus sui generis to law. Pregnancy is not a disease, but it can kill you, and it can run serious health risks. But it is a natural part of life, and it is a necessity for the continuation of the species. So it creates an issue like no other for courts and law and policy. The other issue that arises in connection with the death risk in Chad and elsewhere in the world is whether or not women have access to safe abortion. Women have throughout time, and currently today in the world, have access to abortion services whether they are legal or illegal. And globally in the world today, there is virtually no difference in the abortion rates about whether the law makes abortion a criminal act or whether the law makes it legal. And that's important to remember because we spend so much time here in the United States trying to regulate women's behavior with the criminal law. And right to the north, our neighbors in Canada have no criminal laws regulating abortion. They were struck down in that country in 1988 in a case called Morgentaler. And in the wake of that case, there have not been a reimposition of criminal laws in Canada. And yet women in Canada have abortions at the same time in the arc of pregnancy as they do in the United States. The vast majority are in the first trimester, a smaller percentage in the second trimester, and virtually none in the third trimester. This is not based on criminal law or what the law telling them they can and cannot do, but on women's experience and decision and choices. So I want to now turn to some facts about abortion safety. So this is going to be relevant to the trial and the evidence we're going to talk about in the Texas case. But in the United States, abortion is a very safe procedure. In fact, it's one of the safest medical procedures. The risk of death is exceptionally low. The risk if you go forward with a pregnancy versus having an abortion in the first trimester, the risk with childbirth is 14 times higher than that of abortion. 95% of abortions are in outpatient settings. That means they are done in doctors' offices or clinics, not in a hospital-based setting. And less than a fraction of 1% risk of complications exists. This is why abortion is able to be safely performed in an outpatient setting. And the data that I have up here is from the American Medical Association, and it's data that they have introduced as a friend of the court in an amicus brief in the Texas case that we'll be talking about. And what's important to note, and we'll see some more evidence from the American Medical Association later, is that the American Medical Association doesn't take a policy position on abortion itself, whether it should be legal or illegal. But it has taken a position in these cases against the type of laws we're going to be discussing because they are not evidence-based and they are not justified as a matter of science and health. So after talking about, and I should also just add to this, just the prevalence of abortion in the United States, about 1 in 3 women will make the decision in her lifetime to have an abortion. Another way to look at those numbers is about 21% of pregnancies in the United States end in abortion. So the issues that we're talking about here and the issues presented by the case in Texas affect a large number of women. So just to refresh your recollection about the decision in Planned Parenthood versus Casey in 1992, this was the last time that the Supreme Court took a major look at what was the substantive constitutional right to abortion. The court, of course, had decided the issue first in 1973 in Roe versus Wade, and there had been a wave of battles over restrictions ever since Roe had been enacted. And they all came to a culmination in 1992 in the case of Planned Parenthood versus Casey, which involved a series of laws coming out of the state of Pennsylvania. 2 of the laws, most prominent, to give an example of the things decided in that case, was one law that required women to be offered materials by the state and had to go home for 24 hours before coming back. That was a law that the Supreme Court held up in that case, saying it was an appropriate use of the women's, or an appropriate way for the woman to consider her decision. Another law in that case, which was requiring a woman to notify her husband if she was having an abortion, was struck down by the Supreme Court as putting an unwarranted burden on a woman's right to choose, because it was for those women for whom it would be potentially problematic, even threatening to their health and well-being to tell their husbands, it was a substantial obstacle. And in the Casey case, the court established a new standard for the constitutional review, that a finding of an undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. This is now the standard for constitutional review on restrictions on access to abortion. An undue burden is the standard, and the definition of it is a state regulation with the purpose or the effect of placing a substantial obstacle. I was saying to the faculty this morning when I talk to lay audiences who aren't lawyers, I reassure them if they're feeling lost, that there's some kind of deep legal basis behind this that defines all those terms. Exactly what is an undue burden? What does it mean to have the purpose and effect? What's a substantial obstacle? And I tell them, don't worry, there isn't any. All that we have basically is the statement of the court here and the examples of how they applied it in the Planned Parenthood versus Casey case. They also made reference to what's going to be very relevant in the next case before the Supreme Court about unnecessary health regulations. They say again, if those unnecessary health regulations have the purpose or effect of presenting a substantial obstacle, then they can constitute an undue burden on the right. And the reason why it's key to pull this out is, again, the issues in the Planned Parenthood versus Casey case were not about health regulations per se. They were about things like, do you have to inform your spouse? Do you have to go home and think for 24 hours? Issues that did not go to the procedure itself or health and safety standards. They went to the woman's decision-making, and that's what was at issue in Casey. And we'll see soon why that is relevant. Increasingly, since Casey, there have been a series of laws that have been passed, but in the last 5 years, the pace has picked up tremendously since 2011. There have been over 200 laws passed that restrict access on abortion, and they're having a significant effect in many states in restricting services. And these restrictions take many forms. Some of them are outright bans on abortion as early as 6 weeks, in the case of North Dakota, which is currently going through the courts, as early as 12 weeks in Arkansas. And then this set of cases that we're going to be talking about today, which impose health and safety standards that we have established in trial court after trial court, are unnecessary. So this is what the map looks like of what I've just described, which is the state restrictions that have been passed in the last 4 years. These are the states that have passed significant types of restrictions. And many of those, it's not just one restriction in the state. In the state of Texas, we'll be talking about, there was a series of restrictions. We'll be focusing on 2. You've had restrictions here in Ohio. The next slide shows how many of those are enjoined by court orders. So as you can see right now, there has been a substantial amount of teeth put into applying that undue burden standard in the state and federal courts, and we sue in both state and federal courts, that are keeping these laws from going into effect. And I want you to also remember this map, because this map is what's at stake in the next Supreme Court case. Should the Supreme Court decide with the Fifth Circuit, which I'll talk about in a minute, we would see all that yellow go back to red, and those state laws would go into effect. Should they decide, as many of the lower courts have, that there needs to be some real examination of the medical justification for laws that are having such an impact on access to services, then you should see the yellow stay as it is. So one of the issues that I want to talk about today is I'm going to talk about House Bill 2, which is one of these laws I'm going to call a trap law for targeted regulation of abortion providers. These are laws that are just imposed on abortion providers. They are not imposed on similarly situated medical professionals. And one such law is Texas House Bill 2, which was passed in 2013. Governor Rick Perry at the time called the Texas legislature back into session for a special session so that they could consider this omnibus bill regulating abortion. And Wendy Davis, who's in that picture, was a state legislator who famously filibustered for about 13 hours, in which she was not allowed to leave the stage for any minute, for any reason, or the podium. But nevertheless, eventually House Bill 2 passed, and the 2 requirements, which will be at issue in the Supreme Court case and that were at issue at trial, is an emitting privileges requirement and an ambulatory surgical center requirement. Now, how many people in this room know what admitting privileges for doctors are? That seems about right. I mean, I always think if I didn't do this work, I'd have no idea what an admitting privilege are. Admitting privileges is what allows a doctor in private practice to also be able to come into a hospital and take care of the patient once they're hospital-based. And so doctors may or may not have admitting privileges based on whether or not they have been granted them by a hospital and whether or not they're in the kind of practice which causes them to have a hospital-based practice. Obstetricians, of course, have admitting privileges in hospitals because their patients are going to be giving birth, and birth is largely done in hospital-based practice in the United States. And what about an ambulatory surgical center? How many people know what that is? So again, we have some folks in the room that do. And an ambulatory surgical center, for the rest of us, simply put, is like a mini hospital. They have requirements on the physical plant that require them to be in sterile-like conditions that are used when you are doing surgery that cuts into the body. That is not the kind of surgery that is done in first trimester abortions. So Texas passed this law, and as we're going to talk about in a minute, it's been really effective at closing clinics. And the reason for that is that it is very hard. Both of them have been very hard to comply with by abortion providers. In terms of the admitting privileges, there are a host of reasons that abortion providers don't have them, or after this law went into effect, could not get them. One of them is that, as we go back to that first slide about the safety of abortion procedures, that because abortion is safe, it's very rare to have a hospital admissions. If we're talking about first trimester abortions, Texas requires that 16 weeks abortions and up be done in an ambulatory surgical center. That's not been challenged in litigation, and so that's the standard for 16 weeks and up. So hospital admissions are rare, and hospitals therefore don't get admitting privileges to those who don't actually admit patients to their hospital, or they have requirements that you have to admit a certain number of patients a year for them to give those privileges to you. And to give an example, one of our clients in the state of Texas is a clinic that has performed about 17,000 abortions in the last 10 years. They have not had any hospital admissions. So that would be a doctor at a hospital that requires a certain number of admissions a year not to have privileges. Hospitals also can deny admitting privileges for any reason that they so choose. So there are hospitals in many of these areas that deny admitting privileges to doctors who provide abortions because either they object or because they are concerned that they will get boycotted or in other ways will bring controversy to the hospital. And in fact, some doctors have received letters to that effect in the state of Texas. Other hospitals are moving towards a different kind of care where they have hospitalists, doctors who specialize in hospital-based medicine, on their staff. That's their economic model, that's their delivery care model, and so again, not in a position to give admitting privileges to those. And some require that the doctors live near the hospital, and because of the stigma and the harassment and the outright violence against abortion providers in the history of this nation, as recently as the murder of Dr. Tiller in Kansas 5 years ago, some doctors do not live in the communities but have to come in and serve from outside the communities. So for that reason, they may not get admitting privileges. So one of the key things, if we go back and remember the standard in the Casey case, it talked about laws that have a purpose or effect of presenting a substantial obstacle to women seeking abortion. It's obvious to those who live in the politics of abortion that these laws have been passed with the purpose of blocking access to abortion. Sometimes that purpose is pretty blatant. In Mississippi, which has an admitting privileges law that applies to the one clinic left in the state, the sponsor of the bill was pretty clear in its introduction that the purpose of the bill was to make Mississippi an abortion-free state. But when we go to court to try the case, we got to try to prove up this in other ways than just the anecdotal statements of legislators. So the three ways that you would look at that in constitutional law and assessing purpose would ask, does it target a specific group? If you are targeting a group in ways that you're not targeting a similarly situated group, it may suggest there's an illicit purpose. Does it serve its stated purpose? If it is supposed to promote safety, does it promote safety? And what kind of effect does it have? It is an inference in the law that from effect you can derive purpose. If you're closing 80% of the clinics in the state, it is evidence that your purpose was to do just that when you enacted the law. So in looking at how these play out in the cases, targeting a specific group, and in Texas specifically with HB2, the answer is absolutely. Only abortion providers are subject to the ambulatory surgical center requirement of any doctors in the state. So it does not apply to, for example, if you're an OBGYN and you are doing miscarriage management, which is an essentially similar procedure to an abortion procedure, that's fine for you to perform in your office as part of your practice. Only abortion providers are subject to the ASC requirement and to the admitting privileges requirement. And in both of these, only abortion providers were ineligible for waivers. Ordinarily, when this kind of health regulation comes in about facilities, you could go to the government and say, I've been practicing safely in 25 years and would like a waiver or grandfather for my facility. And ordinarily it's granted. In fact, we've had states where it has been granted. But in Texas, those were all denied, which was further evidence, again, of unusual treatment of a specifically targeted class, which is evidence of illicit purpose. Does it serve its stated purpose? We had 19 witnesses at trial, including those who established that it did not. And this is, again, I'm going to refer to the American Medical Association's brief in this case, which is pretty clear. Again, this is from a group that doesn't take a position on abortion itself. There's simply no medical basis for requiring ambulatory surgical center standards or local admitting privileges. No safety benefits at all. Not no marginal safety benefits, no safety benefits. It jeopardizes women's health by restricting access to abortion providers. and is devoid of any medical or scientific purpose. So the AMA could not be closer or more clear on their view of this. And another kind of interesting aspect of the evidence of that it doesn't serve its stated purpose is one of the arguments of the state of Texas in the case has been that it's okay if all the clinics in a particular area close, and even if it makes it unable to get services in any near distance in Texas, women can just go to New Mexico. Well, there's an illogic there. If New Mexico doesn't have the same requirements as Texas, like ambulatory surgical centers, why is the state saying, well, we can just send them across state lines? Again, evidence of unlawful purpose. Then we come to the effect of the law. And again, one can think that the effect is strong evidence of purpose. What this map shows is the provision of abortion clinics in the state of Texas before and after HB2 passed. So you see on the far left here, there were a little over 40 clinics in the state of Texas before HB2 in 2013. The admitting privileges law, after some unsuccessful litigation, went into effect in November of 2013, and half the clinics in the state closed overnight. Again, there was inability of doctors, particularly doctors. Is anyone here from Texas so that they can understand where the map is? Well, you can see that the clinics, if you look at the November 2013, they're concentrated in major urban areas: Dallas, Houston, Austin, Fort Worth, where the clinics remained open, where there were doctors with admitting privileges. But in other parts of the state, including very underserved parts like the Rio Grande Valley, clinics were not able to stay open. We then brought this current case. The ambulatory surgical center requirement had not yet gone into effect, and we brought this case next. We first tried to get those waivers and grandfather clause so we would not have to sue. Unable to get them, we filed suit, and we also brought a lawsuit specifically on behalf, or as applied, for you law students who are starting to learn constitutional law, as applied to the clinic in El Paso, that would be the one on the end there, jutting out on the left, and the clinic in the Rio Grande Valley, and that would be the one to the furthest south, arguing that not only were they denied privileges that had nothing to do with their competency as medical professionals, but that if you close those clinics, women who are either west of San Antonio or south of San Antonio have no access to clinics, and many would have to drive more than 300 miles round trip. So we brought an as-applied challenge, and what you're seeing there in May of 2014 is the district court giving us an injunction in that case. In terms of what will happen at the next stage, you can see by this map on the far right. If we do not succeed in this case in the Supreme Court, Texas will go down to 10 clinics or less. This is what happened for a small period of time in November of 2014. We had won the case in the trial court. The trial court had found that there was a severe limitation on access to abortion services in Texas, and that the law served no medically justified purpose. And the state of Texas appealed to the Fifth Circuit. The Fifth Circuit lifted the injunction without even hearing the arguments in the case. They lifted it pending appeal. We went to the Supreme Court immediately. What had happened in the 5 days as we went up to the Supreme Court is another half of the clinics in Texas closed, taking it at that time down to about 8 clinics. The Supreme Court reinstituted the stay, pending the appeal in the Fifth Circuit. We were not successful in the case in the Fifth Circuit, which did not surprise us. And once again, the Fifth Circuit was going to lift the injunctions that had been in place. We went back to the Supreme Court last summer, and again, the Supreme Court put the injunction back in place pending our request for certiorari review by the Supreme Court. So the status now is the status you see there with the El Paso and the clinic in McAllen, Texas open, but what threatens to happen is what is here with only 9 clinics. So that is the effect. The brutally effective quote in this slide is from the district court, Judge Yackel in the case, who found that these 2 unjustifiable medical restrictions together, the ambulatory surgical center requirement and the admitting privilege requirement were a brutally effective way to cut off access to abortion services in Texas. And just to remind all of us, Texas is the second largest state in the country. I'm from New York, and I thought that we were like the second largest state in the country, and this has reminded me that this is not the case. It's the state of Texas, and it is also the second largest by land mass. And you can see that Texas has over 5 million women of reproductive age, of a vast amount of land. As you can imagine, 10 abortion providers to be able to, 10 clinics to be able to cover that amount of the population. Based on our previous discussion of what the public health facts are, 1 in 3 women in the United States. Texas does not have different rates than that. To give you a comparison, California has about 500 abortion providers in their state. So that is a severe restriction, and all of this led Judge Yackel to say in his decision that it would lead to an unprecedented percentage of licensed abortion facilities closing across the state and severely limit access. And I should say that Judge Yackel is an appointee to the Federal District Court in Austin by George W. Bush. And so, again, hardly someone that you might think was looking at this as a matter of politics as opposed to facts and application of law. So, reprising what Judge Yackel was looking at, what the Fifth Circuit was looking at, and what the Supreme Court is looking at, what does it mean? What does this mean? What is going to give content to this standard of what is an unnecessary health regulation that has the purpose and effect of presenting a substantial obstacle? That is what is going to be at issue. And some courts have been wrestling so far with defining this. And the Seventh Circuit, there's a case on admitting privileges in Wisconsin. And the Seventh Circuit, in a decision by Judge Posner, when it was up on appeal from the preliminary injunction that had been put in place, put up a test that I think is strong and valid and one that the Supreme Court ought to take on. It, number one, says you have to have evidence. You know, if you're going to pass medical restrictions that close over 75% of the abortion facilities in a state, you need some evidence that there was a sound reason in science and medicine to do that, because we're talking about access to a constitutionally protected right. And so what Judge Posner said is, you know, the feebler the medical grounds and the likelier the burden, even if slight, is undue. In other words, if you've got no justification for this law whatsoever, any burden really should not be justified. And he puts it here in a way that I think makes sense to people. What undue means is it's disproportionate or it's gratuitous. So it's undue if there's just no basis whatsoever, whatever burden it's imposing, right? Or it's undue if it's disproportionate. That if there might be some particularly marginal safety benefit, and again, that was not the argument made about either approved by about ambulatory surgical centers or admitting privileges, but it's closing all the reproductive health care facilities in Texas, then it's an undue burden. Undue, unjustified, gratuitous. The Ninth Circuit adopted a similar type standard when they were looking at a medication abortion restriction that was denying doctors the ability to use the best state of care for their patients on medication abortion. And so the Ninth Circuit, too, says that we got to look at whether it actually advances the state interest. It's not enough for the state to just say, we're going to do that. It has to actually advance it. And if the burden significantly exceeds what's necessary to advance that interest, then it is undue. Similar in Alabama, again, looking at the same sweeping set of laws on admitting privileges, asks again to let's look at the relationship between severity of the obstacle and the weight of the justification. You can't close every abortion clinic in the United States based on something that is marginal at best. Now, the one circuit that's an outlier on this kind of, we've got to take a real look at these laws because, again, we saw the sort of evidence that the district court saw about their illicit purpose is to suppress access to constitutional rights, is the Fifth Circuit Court of Appeals, which, of course, is the Court of Appeals that oversees the state of Texas. The Fifth Circuit doesn't balance. They're not going to balance the effectiveness of the law against the burden the law imposes. What they said in the prior case was basically mere speculation by the state legislature is enough. And as you can imagine, under this standard, it's pretty easy to hold up the laws, even the ones that the district court found to be unlawful. So just to go back, that is going to be the issue. That is going to be the issue in the Supreme Court, and we're going to be looking at the viability of those states right now that have yellow. And I would say that most of those, there are some that are a little bit different in the way they present themselves, but will stand or fall based on what the Supreme Court does. And if they fall and we go back to all the red on the map, you're going to see a sort of remapping of access to abortion services that existed before Roe versus Wade. Because, of course, there were states, New York being one, California being one, that did have access to abortion services before Roe, but we are seeing a kind of repatterning of blocking of access in the wake of these newest TRAP laws. So where does it end? We ask ourselves this a lot at the Center for Reproductive Rights. We've been playing whack-a-mole for a really long time with laws that pop up. I take the state of Oklahoma, for example. We have sued repeatedly in state and federal court over the last 5 years, and we have won, and we have won, and we have won, and we have won, and we have won. But we're back suing Oklahoma again this year because the state legislature comes back every year and passes new laws and new restrictions. And that is true in state after state after state. And so to make the right real, there's going to need to be true federal protection, either with a reassertion of the standard of undue burden, which I believe the Supreme Court intended in 1992, and Justice Kennedy was part of a plurality opinion there, that that was to be a real standard, that was to really balance access to abortion services with the state's other interests. Or we're at a point where it's going to be necessary for the United States Congress to establish a law that gives us the parameters in which we can litigate these cases that make facts and medical evidence and standard of care and scientific data the standard by which these laws have to stand or fall. And just to show where the two are going to play out, there's two cases right now that are sitting, as I said, cert pending in the Supreme Court. One is the case from Mississippi that is an admitting privileges case. It has been sitting for cert review. We have won in the district court. And in that case, we actually had the Fifth Circuit Court of Appeals affirm the preliminary injunction on the grounds that Mississippi would lose its only clinic and the state of Mississippi cannot deprive its citizens of their constitutional rights by forcing them to go out of state. At the oral argument in that case, we had presented to, Mississippi's argument was you can just go out of state. Again, a health and safety regulation that actually doesn't allow any services in your state is questionable. But that was their argument, and we argued back that it was good Supreme Court law that a state can't deny its citizens their constitutional rights by saying they're available next door, and relied on a case out of Missouri in the maybe the 1930s or 40s, in which Missouri was denying its African American citizens the right to attend its state law school. And Missouri's argument was, we will pay them to go to Michigan, and it's a better law school. And the Supreme Court, even then, before having the robust race protection standards that they have now in the constitutional law, said, you can't do that. You can't offload to your neighbors the constitutional rights which you need to guarantee to your citizens. So that was the grounds on which the Fifth Circuit, upheld, at least to date, the injunction against the admitted privileges law in Jackson. And the second case, of course, is the one that we were talking about, Whole Woman's Health versus Cole out of Texas. The Supreme Court has stepped in twice in that case to put the injunction back in place. That means with 5 votes to put the injunction back in place. And so it looks strongly likely both because of their actions and because of the impact that the case would have nationwide were it not taken, that the court may be looking at this term. We have filed our petition for cert, and if the state of Texas files on time, it could be as early as November that the Supreme Court could announce that they are taking the case. And I want to end by talking about the Women's Health Protection Act. The United States Congress stepped in the early 1990s when there was a different crisis happening in access to abortion services. That was in the wake of the repeated blockades and violence and harassment against abortion providers. And finally, the Congress stepped in and said, you know, enough already. Yes, there are local picketing laws and local laws on trespass, but we need to step in with stronger protections so that we have a nationwide accessibility. And the parallels to the present day are striking. The Senate report on the Freedom of Access to Clinic Entrances Act described the problem that was facing, that needed a remedy, and stated that the blockades were, quote, interfering with the exercise of the constitutional right of a woman to choose to terminate her pregnancy, and that such conduct threatens to exacerbate an already severe shortage of qualified providers available to perform safe and legal abortions in this country. It is the same problem, only made worse because the shortage of providers has increased, that Congress is facing today and should look at down the line for establishing protection so that by the ability of legislation, they cannot achieve the same effects that were not achievable through those blockades. And what this would provide, and I'm going to talk about this, obviously it's not passing next week in the United States Congress, but we need to look at it for the long term. Because what it would do would prohibit the singling out of abortion services for regulations that are more burdensome than those restrictions imposed on medically comparable services. So it's not that there would be any special protection for abortion services. They can be regulated as any comparable procedures would be. And it would establish a private right of action, similar to the Voting Rights Act. You can sue in the Voting Rights Act under the Constitution, or you can sue under the Voting Rights Act. And it gives more structure to how the courts have to look at the burdens placed, in that case on voting, in this case on reproductive rights. And it would give the Department of Justice jurisdiction to be able to look at these violations themselves. And this just gives you just a quick look at how the Women's Health Protection Act would operate. It specifically prohibits some types of provisions, like demanding that you are not allowed to use, fact-based standard of care doing medication abortion. But the key to it is that it would have factors that the court could look at with the new and different and creative regulations that pop up year after year after year. And it would look at these objective factors to determine that question we've been talking about today. Is this a true health and safety regulation? Or is this actually designed to be a way to limit the constitutional right to access abortion services? So I just want to end by saying, like all of us here, I come to the issue of access to abortion and abortion rights with my own set of life experiences, personal commitments, and my own religious beliefs. And as the Supreme Court noted wisely in the Planned Parenthood versus Casey case, men and women of good conscience can disagree, and probably always will, about the moral and spiritual implications of ending a pregnancy. In reaffirming in Casey the right that they had originally addressed in Roe versus Wade, the court reminded us that it's the promise of the Constitution that there is a realm of personal liberty that the government may not enter. And whether these principles of Casey will endure in the next battle in the Supreme Court will depend on whether facts, the rule of law, and reasoned argument prevails. So it's not just women's rights that are at stake in this case, but the integrity of our democracy itself. Thank you. I think we have a few minutes
for some questions if you're, Absolutely. If you could just say your name and who you are.
I'm Helen Bell, and I'm an alumni, by the way. You forgot that category when you asked for raising hands. But at any rate, one quick question. You used FGM when you started. I don't know what that means. Could you explain?
Yes. FGM stands for female genital mutilation, which is a procedure done in some parts of the world that have various levels of severity for women and serious childbearing consequences and health consequences.
Hi, my name's Michelle. Historically, we've seen the Supreme Court sort of move in a different direction based on society kind of coming to an agreement on things. So I feel sometimes frustrated that the sort of anti-abortion side has taken over this movement so much in terms of language and how they talk about abortion. And I feel like the pro-choice side has sort of lost that battle a bit. And I wonder if there's any discussion sort of among organizations, pro-choice organizations, to sort of coalesce a bit more about taking back the language, because I think we've seen like sort of this, the preborn, the unborn, this language that sort of makes me a bit nutty. And then also maybe more of a push from sort of like the American College of Obstetricians and Gynecologists to speak out more, sort of more of like the providers to speak forth a bit more, and really talk about the medical benefits of abortion and the societal benefits of abortion, because there are benefits, and I think we don't talk about that enough as the abortion community, frankly.
So having worked on this exclusively for the last 12 years at the Center for Reproductive Rights and earlier in my career as an activist, I think the issue is not so much language or getting the right frame as stigma. I think what's needed going forward, it's needed in this case, is for people to talk about their own experiences with abortion. 1 in 3 women is a lot. It's people in this room. And because it's not talked about, it's highly stigmatized, right? There are huge consequences because of that. The public debate is skewed because I always say, like, you can't protect rights that people aren't going to talk about or own for themselves as opposed to talking for third parties. It makes it hard for doctors who are not abortion providers to stand up for their colleagues because it is so stigmatized and difficult. So that, to me, is what's needed most, is to normalize the conversation and to have people own and talk about why they defend the issue, what it's meant in their lives, why it's important to them. And also to contextualize it within a broader understanding of reproductive health care, is why I started with those figures. We need better policies on all grounds. We have an unacceptable rate of unintended pregnancies in the United States. 50% of pregnancies in the United States are unattended. That's not a way to plan your families. So, some of that has to do with a lot of complex, issues, sociological issues, but also has to deal with not having had good, robust policies on contraceptive affordability, which we do now with the ACA, and to having very particularly American cultural ideas about sexuality and sex ed. I encourage any of you interested to kind of look at the different experience they have in Western Europe and places like Denmark on rates of teenage pregnancy. They're much lower. Again, not because teens behave different in the Netherlands, but because they don't behave different in terms of sexual activity, but in terms of contraceptive use. So I think those are the important things as this debate goes. It is a contested issue. It will always be, I think we will differ on this issue as we will differ on religious beliefs, right? There's never going to be some day in which we agree on religious beliefs. And so I think this will remain a contested issue. But I think for those who want to make clear why they support access to safe and legal abortion, they need to talk about it. Yes.
Yeah,
Sorry.
my name's Lynn. I'm an alumni. Could you touch briefly on what the status here is in Ohio, what kind of laws have been enacted? I saw on your map that Ohio was one where apparently nothing is on hold. So what kinds of limitations I think we're only down to like 6 abortion providers in the state at this point. So what has been the sort of the success story, so to speak, of how these things got enacted here?
Right. So I'm actually, Professor Hill, do you want to address Ohio? Because I have a feeling that we did not litigate those Ohio cases, and so you may be more able to directly address it.
Well, I think we have 7 providers. Is that, yeah, Chris? Yeah, we've had a number of these sorts of restrictions. We don't have an admitting privileges requirement, but we have the ASC requirement. We have a written transfer agreement requirement, which essentially functions like an admitting privileges requirement. We have we were the first state in the country to pass the medication, these restrictions on evidence-based use of RU-486, the medication abortion drug. We have really been surprisingly on the cutting edge of a lot of the anti-access and anti-abortion legislation over the past several years. And Cincinnati, right now there are 2 providers in Cincinnati litigating over the most recent iteration of one of these trap laws, and that if they close, Cincinnati is poised to become poised to become the largest metropolitan area in the country without an abortion provider. Ohio is number 2 in the country in clinic closings, so right behind Texas, basically. So that's the brief, grim overview, I guess.
You might say something about why that Sixth Circuit decision, where that fits on the medication abortion, where that fits in kind of, are they willing to look at the evidence or not?
Right. I mean, we're kind of, the Sixth Circuit, which is our court of appeals, is the court that's on it goes along with the Fifth Circuit in terms of saying, we don't care whether there's any evidence at all that supports these measures as having any health benefits. We only look at how many clinics are going to close, and they didn't hold that we quite had few enough clinics or women affected.
So I'm getting the time. Because never go between you and your reception. So I want to thank you very much. I'll be here for the reception. Happy to continue talking. Love being here at Case Western. Thank you very much.